When you bring a lawsuit against a careless doctor for medical malpractice, now during the course of the lawsuit, when your attorney goes ahead and questions the doctor in a process known as a deposition, what does it mean if the deposition goes smoothly and there are no issues? Would you like to know what it means? Come join me for a walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It means a lot of things. Most importantly, it means that your opponent, the defense lawyer who is representing the doctor, is a professional. It means that the defense attorney who is representing the doctor knows what he's doing. It means that there are no significant fighting that's going on during the course of the doctor's questioning. Now, you should know that during a lawsuit, we have an opportunity to question the various doctors and hospital staff that you have sued. This is a pretrial process that lawyers also call an examination before trial. In pre-COVID times, this would typically take place in the attorney's office, in his conference room. Now, this typically takes place on a Zoom video call. The defense attorney is on the call, the witness, the doctor is on the call, I am on the call, and a court reporter is on the call. Why? To record all of the questions that I ask and all of the answers that the doctor gives. The answers that the doctor gives represents his sworn testimony, and you should know carries the same exact weight as if he's testifying in court, at trial, in front of a judge and in front of a jury. Okay, so what happens now if I'm in the middle of questioning a doctor during the course of your lawsuit, and during this deposition process, I really don't have any problems? The defense attorney is a very professional lawyer. He knows exactly what's going on. He only raises a couple of objections about the way I phrased one or two questions, and otherwise he is allowing his doctor to answer pretty much every single question that I am asking. Now, what does that mean? Some people might be saying, well, he's not doing a good enough job. If he's allowing his client, the doctor, to answer all of my questions without interruption, without objecting repeatedly, he's not doing his job as a good defense attorney. And you know what I say to that? I say I would totally disagree, and I'll tell you why. In New York, there are very few instances where a defense attorney has the legal right and the ability to tell his client, the doctor, do not answer Oginski's question. There are very few instances in which he could legally do that. And the first is, if I ask the doctor about what he talked to his attorney about. Hey doctor, what did you and Mr. Jones talk about concerning this particular topic? Objection, don't answer that question. That's privileged. That's true. I am not permitted to ask the doctor about anything that he talked to his attorney about. So what's the second thing? The second thing is if I ask a totally off-the-wall question, such as, doctor, how many times do you beat your wife each night? What? Now the defense attorney has every right to object and to say that that question is palpably improper. Don't answer that question, doctor. That's true. Now, would I ask that question? No, I would not personally ask that type of question. However, there are some instances where I may ask a question to which the defense attorney objects. He doesn't like the way I phrase the question, or he thinks this particular topic is off limits. Now, what would that be? Let me give you an example. Let's say during the course of the deposition, I want to ask this doctor about whether or not Dr. Number 2 and Dr. Number 3 did something improper, whether they departed from the standard of care. Now, the defense attorney raises a whole big stink about it and says, hold on, Oginski, you are not permitted to ask my client whether or not Dr. Number 2 and Dr. Number 3 committed malpractice. You're not allowed to, especially because they are not part of his medical group. They are not acting in concert. And now the defense attorney tells me that Dr. Number 2 and Dr. Number 3 have nothing whatsoever to do with Dr. Number 1. They were not treating the patient together. They were not part of the same medical group. They're not affiliated with the same hospital. And now he tells me, listen, you're trying to use my doctor, my client, as an expert against the other two doctors you sued. In that instance, the defense attorney would be well within his right to raise an objection and to direct his client not to answer that question. And of course, I have a problem with that. Why? Because in New York, I am technically permitted to ask the doctor many, many different types of questions, and theoretically, they are supposed to answer all of the questions except for the issues I mentioned earlier. If it involves attorney-client privilege, and if I ask a question that is so off the wall that it is palpably improper. So now, if a defense attorney does not give me a hard time because I am asking appropriate questions, and now I'm sticking to the issues in the case, and now he understands why I'm asking these questions, does it make a difference? The answer is it does make a difference. because it tells me that this defense attorney knows exactly what this case is about. He's fully aware about what the issues are in the case. He knows what the doctor can and cannot answer. He knows what the doctor should and should not answer. Now, how does that affect your case? Because now, at some point later on, as your case progresses through the litigation, we can now have an honest conversation with the defense attorney about the merits of your case to see whether or not there's a basis to go forward and try and negotiate. The defense attorney is going to come back and make arguments on the merits of whether or not you have a basis for a case. Over the course of my career, I have had attorneys, defense lawyers who have opposed me during these depositions where I am questioning their client, the doctor, simply go ahead and make one objection after the next, and make these outrageous arguments. Why? For a number of key reasons. One, they want to disrupt my train of thought. Number two, and by the way, you may think that that's a good strategy, which I would argue is not. Number two, they want to show their client, the doctor, that they're just not sitting on their hands saying nothing. That they're there and they serve a purpose and they serve a function, and their job is to totally disrupt anything I'm trying to do. Again, I would argue that that is not a good purpose and function for an experienced defense attorney. Number three, they want to try and get me to argue with them so that now I will disclose to them many of my theories about why I should be asking this doctor certain questions. Now, I have no problem disclosing with the defense the different theories that we have against the various doctors in the case. And by the way, you should know it's no secret, because before we even get to the deposition stage, I am required to disclose to the defense exactly what our theories are, what our claims are against the various doctors. And each doctor is required to have an itemized, detailed document called a Bill of Particulars that sets forth exactly what our claims are against each individual doctor. By the time when we go ahead and start depositions, the attorney will know full well exactly what our claims are and what our theories are. He's not going to learn about it for the first time when I start questioning his client, the doctor. Why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but have not done so because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.